We're about to move into admissibility, and then we'll pretty much wrap up with that. And prior to admissibility, in any trial, even if you don't launch a full-blown war against, the proffer of evidence, you do have cross-exam, right? And a quote that you probably saw a lot over the years is cross-exam is a great tool for discovering truth or falsehood or whatever. So here are the sort of questions you can consider asking for a validated method. Is the DNA a mixture of two or more people? That's a reasonable question. If it's a mixture case, the answer should be yes. How did you calculate the match statistic? Usually it's done with software, so what software they use? What program was used? What's the scientific basis of that calculation? That will probably lead you, if you pursue it, and you don't end with the first answer, but you say, okay, what's the scientific basis for that statement? And you just track it down, you'll actually find out what the scientific basis is. You want to know if the method's been validated. Does it have a false positive rate? And what is that rate? How has its reliability been demonstrated? Where are the peer-reviewed validation studies? And that leads us into, briefly, I'm not a lawyer, but I'm going to mention this anyway, Rule 702. This must be something comparable in Pennsylvania that we'll hear about soon. Testimony of expert witnesses. But the basic idea of this rule of evidence is once you have facts or data, you need to take reliable methods and apply them to the data in order to produce some reliable result. So this is under reliability. And with the data that comes out of crime labs, this is amply met. There's no question that the way that the methods are of generating these signals is phenomenally reliable. So the question now turns to, with more challenging DNA evidence, is how was it interpreted? What's the procedure for interpreting? Is it a reliable method that's been applied to this mixture data? We're not a Daubert state, so this might seem irrelevant, but I'll show you why it is relevant. In Daubert versus Merrell Dow, there was this plaintiff who said that Bendectin, which is a drug that Dow Pharmaceuticals produced, caused birth defects. The defendant argued there was no reliable scientific evidence, and the Supreme Court ruling overthrew at least for federal and level in half the states, the concept of the Fry standard, which is number 5 alone, generally accepted methods in the scientific community, and introduced the judge explicitly as a gatekeeper and said that these methods need to be testable and tested. Number 2, there should be peer review and publication. Number 3, a known error rate. And number 4, standards and controls for how these methods are used. This isn't, every criteria doesn't have to be met, but these are guidelines, and often many or most of these are met before evidence is introduced. And in Fry states, the last one, general acceptance, is the main thing. Allele has undergone admissibility challenges in a lot of places. In the U.S., there have been 6 challenges so far in Pennsylvania, California, Virginia, Ohio, Louisiana, and New York. And there are different states. There's Fry, there's Daubert, there's some sort of combination. In Pennsylvania, the Foley case happened long ago in 2009, but there's appellate precedent. And New York just issued its Fry ruling in a homicide trial this month. A few weeks ago, we posted all of the summaries of these results with all the rulings and decisions that we had available, and they're all up on our website if you'd like to read them. It's very entertaining if you like reading these sorts of rulings. But I'm just going to quickly talk about Pennsylvania and New York. The Foley precedent came about, this is the case of the state trooper in Indiana Township who murdered the dentist in Blairsville. You may be familiar with the case. At that trial, the original inclusion statistic was 13,000, and that was the main evidence. DNA under the victim's fingernails, that was 7% of the mixture. Who was this other 7% contributor? And the true allele number was 189 billion. And so a lot of what went into that in the defense was arguing, well, if you keep getting different numbers, what's reliable? So that the judge ruled that true allele was in and the DNA was in. Mr. Foley was convicted. It went up to the appeals court and the Supreme Court, and that ruling is on our website. You can find it easily other places. And that established a precedent for true allele's reliability in Pennsylvania. So we've done a lot of cases in Pennsylvania. I think it's more than 40, but under 50 so far. Let me just quickly tell you about the Wakefield case in New York, where Judge Michael Cocooma, who's a very senior judge, he's Deputy Chief Administrative Judge for upstate New York, ruled on a Fry hearing that lasted for a week in October in Schenectady. If you want to read the ruling, or the decision, these are the main areas he focused on. Peer review, he looked at the articles that had been published about the system and about its reliability. He considered validation studies that had been published, but also independent studies that had been done by the New York State Lab and other labs. He looked at relevance to the scientific community. I'll show you something in a second. New York State has a special procedure for that, as well as legal acceptance. And then he heard a week of expert testimony. In New York State, it's one of 5 or so states that has a forensic science commission with a DNA committee that assesses systems. And the New York State Police and Cybernetics went before this committee for maybe 3 or 4 times over an 18-month period, and ultimately the Scientific Advisory Board, as well as the full commission, stated that True Allele was reliable based on scientific evidence. And since the committee members are drawn largely from outside of New York State, they're well-regarded national or international experts that had meaning, even in this admissibility hearing. We also had used True Allele for other projects. For example, in New York State, we had reanalyzed the World Trade Center victim remains, so about 18,000 highly degraded DNA samples, and also analyzed the 2,700 missing people DNA from personal effects and families, and then made comparisons and provided that information to the medical examiner. And so there was a lot we had done in New York, and the findings of the judge were that the evidence shows that computerized probabilistic approaches and likelihood ratio principles used by True Allele are superior to the current methods. He also said, moreover, True Allele has been demonstrated to be one of, if not the most advanced method of interpreting DNA profiles for mixed and low template DNA. That's when you have low amounts of DNA. And he also concluded, this is just his last paragraph, that it has been proved to be more accurate than CPI and CLR, those are the threshold approaches, preserves more of the identification information, eliminates examiner bias, produces a match value which human review may not, and permits standardization of mixture reporting, whereas human review approaches can lead to very different match statistics on the same DNA data. And this he was echoing what 10 years of national studies had shown as well. It's in the transcript, but as an aside, at the very end, after the defense and the prosecution went back for a few days of testimony, he asked me questions for about half an hour. And one of his last questions was, does the crime lab community, United States, know about this? I answered yes, they'll know about it, but change can be slow.